Welcome back to Ask a Lawyer. Let's listen in as attorneys Mark Avera and Jack Bove discuss wills and what having one might mean to you and those you love.
Jack, we want to draw on your experience drafting wills for clients and folks in our community. Tell the folks out there who should consider having a will drafted.
Mark, anyone who has assets and who is concerned about where those assets will go after they pass away should have a will that directs the disposition of those assets.
Sometimes folks go online nowadays and they can find websites where forms are provided for them. Is it a good idea to download a form off the internet to execute your will?
I don't think so. I would liken that to Christmas Eve at my house when I'm running around trying to assemble the children's Christmas presents and I'm wishing the instructions were better, that I could call someone with a quick question. I'm a firm believer that folks should consult an attorney who has experience in drafting wills and spend a little money and get quality advice, and that way they'll be sure that after they pass away their wealth goes where they wanted it to go.
Are there requirements in Florida that for the will to be drafted in a certain way, and that if that's not followed, the will is held to be invalid?
There are. That's a great point too about some of these internet products. The Florida statute requires that the will be signed at the end and that the will be signed in the presence of two witnesses, and that means everybody's in the same room at the same time, and you wouldn't necessarily know that if you downloaded something off of the internet, and that's a great source for will contests.
From time to time, are you asked by folks to look at wills to make sure they comply with Florida law, to make sure that when they're admitted to probate, they're held to be valid?
I am. We were looking at one just yesterday, as a matter of fact. Some folks moved here from out of state, and unfortunately, the will was not witnessed at all. And so we're advising those folks to not only have a Florida will, but obviously have it executed appropriately. Is
there any way to take a will that doesn't comply with Florida law and make it valid under Florida law if it doesn't comply with the things in the statute?
Sure, assuming that the client's still alive. We just get the client to come in and tell us what the client really wants in the will, and we'll prepare a new will, have it properly executed, and the minute that the new will is executed, then the old will is automatically invalidated.
What happens if you pass without a will in place? How are your assets allocated if you do not have a will in place?
Any of several ways. One is under the Florida intestacy statute, which the state legislature has said if you don't have a will, here's where we think your assets ought to go, which may or may not be what the client really wanted. But that's an interesting point too, because if you think about it, if you have life insurance, when you bought your life insurance policy, you designated a beneficiary, and so the life insurance proceeds will go to that beneficiary because that asset is going to pass by contract. Or if you and your wife own a home jointly and you die, then the house is going to go to your wife by operation of the deed. Or if you and your daughter own a bank account jointly and you pass away, the bank account will go to your daughter under that joint tenancy. So there are other ways that assets can pass besides a will.
Now you mentioned life insurance. Are life insurance proceeds, are they considered part of your assets when you pass?
They are for federal estate tax purposes. One of the things that people have to keep in mind in these conversations is that the federal government is circling around, and if you pass with more than $2 million in assets, and you leave those assets to someone other than your spouse or to a charity, then the federal government's going to get 45% of that excess over $2 million, and life insurance is part of that calculation.
Are there things that you do with your clients to help them ensure that life insurance proceeds are not considered part of those assets?
Yes, we are allowed under the Internal Revenue Code to buy that policy inside of an irrevocable trust that's not part of the client's estate, and therefore that life insurance can pass estate tax free to the heirs.
I ran across an issue with one of my clients recently where there was an issue of apportionment of taxes, and apparently there was a new statute that came out in the late 90s and 2000 that required that you either have the statute or make some reference to the statute to ensure that your estate paid for taxes only and no individual person. Explain to us a little bit how that works, please.
Tax apportionment is an area that's fraught with danger. If I have that life insurance policy, it's going to pass perhaps to my children under the life insurance contract. And how is the IRS going to get the tax on that? And are they going to assess the tax against my children and try to get some of the proceeds, or are they going to assess the tax against the rest of my estate, which might be going to my best friend, for example? And so as people prepare their wills, they need to think about how the tax is going to be apportioned.
And the things that we've discussed today, Jack, are these the kinds of things that you can help folks with?
Absolutely, Mark.
Thank you for your time.
Thank you.